You're listening to the Bare Metal Cyber Prepcast, created to help you succeed in your educational journey. Learn more at baremetalcyber.com, where additional prepcasts, books, and training materials await. Let's get started. The Privacy Protection Act of 1980, or PPA, was enacted in response to growing concerns about newsroom raids and the chilling effects such actions could have on press freedom. The statute created strong protections against government searches or seizures of media work product, making it clear that investigative tools should not be used to bypass the protections of the First Amendment. At its core, the Act embodies the principle that journalists must be free to investigate, gather materials, and develop stories without the constant fear that their files or notes might be seized by authorities. For learners, the PPA is an essential example of how privacy law intersects with press freedom. It reflects the recognition that confidentiality in newsrooms is not a private luxury but a public necessity, safeguarding the independence of journalism in a democratic society. A central feature of the PPA is its distinction between work product materials and documentary materials. Work product includes drafts, notes, and other preparatory documents created by a journalist during the news-gathering process. Documentary materials, by contrast, refer to broader records such as photographs, tapes, or computer files containing information used in reporting. Both categories are shielded under the Act, but the definitions are significant because they delineate the types of content that require heightened protection. For learners, this distinction highlights the practical realities of investigative journalism. The law recognizes that protection must extend beyond published articles to the raw inputs and creative processes behind them, because those inputs often include confidential sources and sensitive data, whose disclosure could have chilling effects. The PPA establishes a strong preference for subpoenas over search warrants in media investigations. Subpoenas allow for judicial oversight, provide the newsroom with notice, and give it an opportunity to contest or narrow the demand. Search warrants, by contrast, are executed without prior notice, making them far more intrusive and damaging to press independence. For learners, this preference illustrates how procedure shapes privacy outcomes. By prioritizing subpoenas, the Act embeds transparency and due process into investigative requests, ensuring that compelled disclosure is not achieved through surprise or coercion, but through structured legal channels, where arguments about scope, privilege, and necessity can be heard. Despite its protections, the PPA allows for limited exceptions in narrowly defined circumstances. For example, authorities may use search warrants when there is probable cause to believe a journalist has committed a crime, when immediate seizure is necessary to prevent death or serious injury, or when materials are at risk of imminent destruction. These carve-outs reflect the recognition that press freedom cannot operate as an absolute shield in all scenarios. For learners, these exceptions illustrate the balancing act at the heart of privacy law. Strong protections preserve the independence of the press, but narrowly tailored exceptions recognize the government's obligation to act in cases of urgent or extraordinary threat. These limits remind us that even vital freedoms exist within frameworks of proportionality and necessity. Procedural safeguards also govern how compelled acquisitions of newsroom material must be handled. Courts emphasize narrow tailoring, requiring that any request be limited to the specific records necessary for the investigation. Fishing expeditions where investigators cast wide nets over a newsroom's files are explicitly prohibited. For learners, these safeguards highlight the importance of scope control as a privacy principle. Just as minimization applies in surveillance contexts, compelled media disclosures must be carefully bounded to prevent collateral harm. Procedural discipline ensures that investigative needs are balanced against the risk of undermining press independence, reinforcing that the state's power must be exercised with restraint and accountability. The Act also provides civil remedies and damages for unlawful searches or seizures. If authorities violate the PPA, affected media organizations can bring suit for damages, including costs and attorneys' fees. For learners, these remedies demonstrate the principle that privacy protections must be enforceable, not merely symbolic. Rights without remedies often lack meaning. By allowing lawsuits, Congress ensured that newsrooms could defend their independence and hold government actors accountable. This remedy framework also serves as a deterrent, incentivizing agencies to respect the boundaries imposed by the PPA rather than risk financial liability and reputational harm for unconstitutional overreach. The issue of unpublished source materials ties closely to concepts of reporters' privilege. While the PPA protects against searches, broader doctrines address whether journalists can be compelled to reveal sources in court. The idea of a reporter's privilege is not uniformly recognized under federal law, but exists in many state courts, where it provides qualified protection for confidential sources. For learners, this dual system illustrates the patchwork nature of media protections in the United States. The PPA covers physical and digital newsroom materials, but broader confidentiality relies on a mix of constitutional interpretation and state-level shield laws. Understanding how these frameworks overlap helps explain both the strengths and limitations of media confidentiality in practice. State-level reporter shield laws further reinforce protections, but their scope varies widely. Some states grant absolute privilege for confidential sources, while others recognize only a qualified privilege that can be overcome by showing compelling need. For learners, this variability illustrates how privacy and press protections depend heavily on jurisdiction. A national media outlet may face different obligations depending on where a case is litigated, creating complexity for compliance. This variability also demonstrates how federalism shapes privacy governance. Federal statutes like the PPA create baseline protections, but states retain the ability to expand or refine those safeguards within their own courts. As journalism increasingly relies on third-party platforms, new questions arise under the Stored Communications Act and other statutes. Emails, cloud storage, and collaborative platforms often hold sensitive newsroom records. The PPA's principles apply, but the involvement of third parties complicates issues of custody and control. For learners, this highlights the evolving challenge of digital media privacy. Confidentiality is no longer confined to newsroom filing cabinets, but extends across distributed cloud ecosystems. Statutory frameworks must adapt, ensuring that protections follow the data regardless of whether it is stored in physical archives, on internal servers, or in external cloud environments managed by third-party providers. The rise of digital records, cloud computing, and social media has further extended the relevance of the PPA. Courts must now consider how principles originally written for physical documents apply to digital posts, encrypted drives, or multimedia archives. For learners, this underscores the adaptability of privacy principles. The technology may evolve, but the values remain constant. Journalists must be protected against intrusive government action that could chill reporting or expose sources. The challenge lies in interpreting decades-old statutory language in a way that meaningfully applies to 21st-century newsrooms, ensuring that protections remain robust even as the medium shifts. The PPA also operates alongside doctrines prohibiting prior restraint government efforts to prevent publication in advance. While prior restraint bars censorship before stories are released, compelled disclosure mechanisms regulate access to materials after they exist. For learners, this comparison helps clarify the distinct but complementary roles of constitutional and statutory protections. Prior restraint prevents preemptive censorship, while the PPA prevents intrusive seizures. Together, they form a layered system of safeguards designed to preserve press independence. Understanding this contrast illustrates how different legal tools converge on the shared goal of maintaining a free and robust press. Protective orders and gag orders often govern how seized media materials, if lawfully obtained, may be used or disclosed. Courts may impose strict controls, limiting dissemination to specific investigators or requiring destruction after use. For learners, these orders demonstrate how privacy principles extend even after disclosure. Just as minimization limits apply in surveillance, protective orders ensure that compelled media records do not migrate beyond their authorized use. This reflects the enduring principle of purpose limitation. Information obtained under exceptional circumstances must remain confined to the purposes for which it was originally compelled. Cross-border demands for journalist data create additional complexity. When foreign governments request information from U.S.-based media outlets, issues of comity and conflict with the PPA arise. Providers may face tension between U.S. protections and foreign obligations. For learners, this dimension illustrates the globalization of privacy and press protections. In a networked world, confidentiality cannot be considered solely within national borders. Legal frameworks must anticipate and reconcile conflicts between different jurisdictions, preserving press freedom even when international demands threaten to erode it. Finally, organizational readiness is an essential part of newsroom governance under the PPA. Media organizations must have policies and playbooks in place for responding to subpoenas, search warrants, or other legal demands. These include procedures for verifying validity, engaging counsel, and protecting source confidentiality wherever possible. For learners, this demonstrates the practical side of privacy law. Statutes provide frameworks, but organizations operationalize protections through training, preparation, and disciplined response. Readiness ensures that when legal process arrives, responses are not improvised, but guided by clear standards that protect both the rights of journalists and the trust of the public. For more cyber-related content and books, please check out cyberauthor.me. Also, there are other prepcasts on cybersecurity and more at baremetalcyber.com. Compelled disclosure involving journalists often arises in both civil and criminal contexts, and the standards governing such demands are shaped by constitutional values as well as statutory rules. Courts generally apply balancing tests, weighing the evidentiary needs of a party against the public interest in protecting press freedom. In criminal cases, prosecutors may argue that a journalist's notes or testimony are essential for proving guilt, while defense attorneys may claim access is needed to ensure fairness at trial. Civil cases might involve libel or defamation claims where unpublished material could be sought to test accuracy. For learners, these scenarios underscore the tension between truth-seeking in the justice system and the independence of the press. The balancing framework reflects a recognition that both interests are legitimate, but neither should automatically override the other without careful judicial scrutiny. A central component of this framework is the protection of confidential sources. Many states recognize a qualified privilege that allows reporters to resist disclosing the identities of individuals who provided information under promises of anonymity. This privilege is not absolute. Courts may override it if the information is highly material and unavailable through other means. For learners, this qualified privilege demonstrates how privacy principles are extended into the newsroom. Confidentiality of sources not only protects individual whistleblowers from retaliation, but also sustains the flow of information to the public. Without it, potential sources may remain silent, weakening investigative journalism. The law thus recognizes that protecting confidentiality serves a broader societal purpose, even if it occasionally conflicts with evidentiary demands. Motions to quash or modify subpoenas are common defensive tools for media entities. When served with a subpoena, news organizations may argue that compliance would be overly burdensome, irrelevant, or destructive to source relationships. Courts often apply burden-shifting frameworks, requiring the requesting party to demonstrate that the material is essential and cannot be obtained elsewhere. For learners, this procedure illustrates how due process protects the press. Journalists are not left defenseless against legal demands. They are empowered to challenge scope and necessity. This mechanism ensures that compelled disclosure is the exception, not the rule, and that courts actively mediate between competing interests rather than leaving decisions solely to litigants or investigators. Grand jury subpoenas directed at media organizations create particularly sensitive conflicts. Grand juries operate in secrecy, and their powers are broad. But courts have recognized limits when subpoenas risk undermining press freedoms. Judicial review often requires that prosecutors demonstrate necessity and narrow tailoring before forcing compliance. For learners, this context highlights the high stakes of secrecy versus transparency. Grand juries serve essential investigative functions, but unchecked subpoenas could erode press independence. By imposing limits, courts signal that the press is not immune from accountability, but deserves special consideration given its constitutional role. This balancing reflects the judiciary's role as a safeguard against overreach in the context of powerful investigative tools. Newsrooms increasingly adopt structured response playbooks to manage legal process. These playbooks outline steps for engaging counsel, preserving records, and verifying validity of requests. Coordination ensures that legal teams, editors, and journalists respond consistently and protectively, rather than improvising under pressure. For learners, this governance model demonstrates the operationalization of statutory rights. The Privacy Protection Act may set boundaries, but organizations must implement procedures to activate those protections in practice. Playbooks also reinforce the culture of readiness, reminding journalists that legal demands are not abstract risks, but foreseeable events that require disciplined responses to preserve both compliance and press freedom. When compelled disclosure cannot be avoided, chain of custody procedures and minimization strategies become critical. Materials must be carefully segregated, with access limited to authorized staff, to prevent overexposure of unrelated content. Courts may require in-camera review, where judges privately examine sensitive materials to determine what must be produced. Redaction is often employed to shield confidential details while still complying with disclosure obligations. For learners, these safeguards illustrate how privacy principles persist even when the press must yield to judicial authority. The goal is to limit the damage, preserving as much confidentiality as possible while still satisfying evidentiary demands. This reinforces the idea that compelled disclosure is not binary but subject to careful shaping by procedural discipline. Notice requirements also play an important role. In some jurisdictions, journalists and even sources must be notified if their records are being disclosed, giving them an opportunity to contest or prepare. Where secrecy is required, protective orders may restrict dissemination of sensitive details. For learners, these notice mechanisms reflect the transparency principle in privacy law. Even when compelled access is necessary, affected parties should not be blindsided unless there is a compelling reason. Notice empowers challenges and fosters trust in legal processes by demonstrating that surveillance or seizure is not happening in complete secrecy, but under structures that provide opportunities for oversight. Third-party doctrine issues further complicate media confidentiality. Telephony metadata, email logs, and cloud storage records are often held by service providers, not newsrooms. Under traditional doctrine, individuals have reduced expectations of privacy in data held by third parties, making such records more accessible to investigators. For learners, this doctrine illustrates the vulnerability of modern journalism in digital ecosystems. While the PPA protects against direct newsroom searches, third-party records may still be compelled under lower thresholds. This tension highlights why statutory reforms and contractual protections with service providers are increasingly important. Journalists must now consider not only their own archives but also how external platforms treat their data when served with legal process. Transparency reporting by technology platforms adds another layer of accountability. Major providers publish aggregate data about government requests, including those potentially targeting media accounts. While not specific, these reports shed light on the scale of access attempts. For learners, transparency reporting shows how private companies can act as allies in preserving press freedoms. By disclosing trends, platforms empower public debate and alert journalists to potential risks, even if individual cases remain confidential. This creates an ecosystem where transparency is layered. Statutory safeguards, judicial oversight, and corporate reporting all reinforce each other to ensure that compelled disclosure is not invisible. Training and simulations are also part of newsroom readiness. Staff must be prepared to handle on-site visits by law enforcement or remote subpoenas, knowing what rights apply and when to call legal counsel. Simulations reduce panic and errors during real events, ensuring that responses are disciplined and protective. For learners, this reinforces the idea that law must be paired with culture. Statutes like the PPA cannot achieve their goals if organizations are unprepared in practice. By training staff, newsrooms turn abstract rights into lived protections, ensuring that the principles of confidentiality and independence are maintained even in moments of legal pressure. Large national outlets face the added complexity of operating across multiple jurisdictions with varying shield laws and privileges. What is protected in one state may be vulnerable in another, requiring careful coordination by counsel and editorial teams. For learners, this variability illustrates the patchwork nature of U.S. press protections. National organizations must navigate uneven terrain, harmonizing their practices while recognizing that uniform rules do not exist. This reality underscores the importance of governance at scale, where consistent policies must account for variable legal backdrops. Multi-jurisdictional challenges remind us that privacy and press freedom are not monolithic but context-dependent, requiring constant vigilance and adaptation. In synthesis, media protections align statutory safeguards like the PPA with operational controls within organizations. Compelled disclosure is not eliminated but tightly constrained, with subpoenas preferred over warrants, exceptions narrowly defined, and procedural safeguards like redaction and in-camera review available to protect confidentiality. For learners, this alignment illustrates the interplay between law and practice. Statutes provide the outer shell of protection, but real-world resilience depends on newsroom governance, training, and culture. Together, these elements sustain the delicate balance between evidentiary needs of the justice system and the indispensable independence of the press in democratic society. In conclusion, the Privacy Protection Act and related doctrines create a layered system of protections for journalists, balancing strong confidentiality with narrow exceptions. Compelled disclosure is managed through subpoenas, privilege doctrines, and minimization safeguards, while readiness policies and multi-jurisdiction coordination ensure resilience in practice. For learners, the synthesis is clear. Media confidentiality is not absolute, but it is robustly protected through a combination of statutory design, judicial oversight, and organizational governance. The enduring lesson is that protecting journalists protects democracy itself, making disciplined process management as essential as the legal frameworks on which it rests. Thanks for tuning in to the Bare Metal Cyber Prepcast, your trusted source for cybersecurity news and insights. Remember to subscribe at baremetalcyber.com so you never miss an update. And visit cyberauthor.me for best-selling cybersecurity books that equip you with expert knowledge. Until next time, stay secure and stay vigilant.